I am a partner in the technology transactions group of Goodwin Procter, and we've got offices everywhere, but I'm in the Redwood City office. All right, so the current state of the law for generative AI. So a lot of people, kind of look at generative AI and they think, well, it's the wild, wild west, and everybody's getting sued, and there's all these cases out there, and no one really knows what the courts are going to hold, and is Congress going to do anything? The reality is that right now there is a fair amount of uncertainty, but there are also very clear legal frameworks that we've been operating under for many years that apply and that help us think through, the legal issues that people have and legal questions that they have when they're creating their generative AI product or their technology. So right now, what's the state of the law? There's no comprehensive federal law that governs AI or machine learning. The EU is in the later stages of passing their AI Act, and their legal framework is expected to break things down by levels of risk, right? So it's essentially a risk-based analysis. And if you are using AI for something that's very high risk, you just can't do AI. If it's high risk, then you can do it with certain guardrails. Low risk, et cetera, minimal risk, then the requirements kind of tier down from there, right? So that's what they're looking at. The U.S. What we've got is, we've got a bunch of states that have proposed legislation out there, right? Right now, New York City has passed legislation around the use of AI for employment decisions, right? The EEOC has guidelines around use of technology generally that may have an adverse impact on specific demographics, right, or on demographic groups, protected demographic groups. Beyond that, right, there's not really much in terms of like potential federal legislation, but we do have the U.S. Oh, it looks like we've got a technical issue there. Okay, in the U.S. we do have the FTC Act, which prohibits false and deceptive statements in the marketplace, right, or practices in the marketplace. And so that's where you'll see for a lot of generative AI companies requirements that they explain to the user, hey, you're interacting with AI, and you'll see OpenAI requires that folks who kind of use their platform to offer products to consumers, that they have the limitations of the use of AI kind of made clear to the user, right? So folks are operating under these types of frameworks, right? I'm personally am an IP lawyer, and so within the framework of IP, you'll see a lot of different things, right? For example, the use of training data to train these large models, right? A lot of folks right now are kind of hinging their argument on fair use, right? And so fair use is a concept that has been around forever. It's enabled a lot of technologies, and so we'll see. Google got sued by a bunch of content creators, and so they are kind of a lot of times at the forefront of making the fair use argument and trying to shape law for the fields that they're in. All right, so part of what I want to do today, because I think most of you are developing AI products, is just give you a sense for, if a user or a customer is looking to buy your product or subscribe to your product, what are they concerned about, right? What could potentially be a roadblock for you as you sell to your market, right? And so part of this is understanding what are they thinking, so that you can shape your technology, your product offering, and your strategy in a way to kind of optimize things from the very beginning, right? Rather than trying to kind of adjust things later, on the fly as you get customer feedback, right? So what are customers concerned about? They're concerned about confidentiality, right? They're concerned that GenAI platforms may not protect their trade secrets or other confidential information. Why may that be the case? Well, for one, right, they want to make sure, they're going to want to make sure that the terms that govern the use of the technology protect the confidentiality and the security of their information and their data, right? But even beyond that, right, in a lot of terms, what you'll see is you'll see a confidentiality provision, but then breach of the confidentiality provision is not excluded from the limitation of liability, right? And so customers will look for things like that, and they'll want to know that, okay, well, number one, do I even have confidentiality protection? And if I do I have a meaningful remedy should this vendor or provider violate that confidentiality or violate data security, okay? The other thing that you'll see in terms of kind of, concerns about using GenAI platforms is there is a fear among users that the inputs could become the outputs, right? And so you've kind of seen kind of the big newsworthy case of that when Samsung banned the use of GenAI after notes from an internal meeting they realized could become output for users of ChatGPT, right? And so that's one of those things where I don't know how prevalent something like that is, but because that specific instance was made very public, now there's just a fear among users of GenAI platforms that their inputs, their queries will be used to train models and could become part and be revealable as part of output for someone else, right? Now you all probably know, right, that OpenAI changed their API terms so that it went from being default opt-in to using data for training into being default opt-out, right? But even for consumers, so if you're not using OpenAI's API, right, then for, if I'm just using ChatGPT, for example, I am default opted in to using my data for training, right? So if there's a company whose employees are using ChatGPT and they don't opt out, and then they throw a bunch of confidential information into ChatGPT, it can and probably will be used for training OpenAI's models, which could then result in sensitive information potentially being revealed, right? So that's another big concern that that customers or users may have. The last thing on this slide is, a customer has to think about their own data privacy obligations to their customers, right? So you have to think about, well, your customer has, if they're offering a product to their customers, they're going to have a data processor addendum potentially, right, where they agree in their DPA to treat any personal information in specified ways. So then if they're using a GenAI platform, they're going to want to make sure that sub-processor DPA essentially has those protections that will then allow them to comply with their obligations. So IP concerns. So there are a wide variety of IP concerns, but I would say that the main ones kind of fall into a couple of categories, right? One is that U.S. law doesn't recognize anyone other than a human being being an author for copyright purposes or an inventor for patent purposes, right? And we've seen the Copyright Office, the Patent Office, basically come out with withholdings that basically said, hey, if this invention didn't involve meaningful human inventorship or authorship, then we're not going to grant a copyright or a patent to that. Which basically means that if something is created using generative AI, then if it's intended to be proprietary to the user of that tool, then it's not going to be unless the user of that tool, has some sort of human-in-the-loop type of, involvement where, they can actually show that there was meaningful contribution of an author or an inventor, right? The second, kind of big bucket of IP concerns here is, whether the output of the tools could create an infringement issue for the person using the generative AI tool, right? So if you think about someone using Copilot and they use that to generate code, if Copilot was trained on some open source software that then essentially finds its way into the output, right, then the user of that code could be subject to a claim for infringement, right, for using for infringing the copyright in the open source software, right, and not following the terms of the open source license, right? Because under any open source license, you're required to include notice and attribution and things like that, right? And so if you're not including that, are you, violating the open source license? And if you're violating the open source license, are you then infringing the copyright in the open source code, right? And so, the first question is always going to be, where did you get the data or the content on which the model was trained, right? The ideal case is that it's in-licensed, right? And so what that basically means is, there was a data set out there, and you paid for the rights to use that content and that data to train your model, right? And assuming that you operated within the scope of that license, then there are no IP issues around using that data, right? The reality is, we're probably, while we're starting to see business models kind of adapting to that, right? Where you see sources of data or content actually licensing their content for the purpose of training models, right? I think we're still in an early stage there, and it's unclear to folks like, how much should I be paying for this right to use this data or content to train, right? So as a data point, right, an example, one of my clients was asking us, hey, we're talking to a data set provider, and they want to charge us 1 cent for each piece of content. I believe it was photos, that we use in order to train our models, right? And so, they asked us, well, hey, does that sound like it's about right and, about market for the fees? And the reality is, like, we don't know yet, because there aren't enough data points. This type of practice hasn't, yet kind of become the norm. But I think over time it will be, right? Because if because that way, the GenAI platform gets certainty around the legal issues, and then the content holders are compensated for their content. Okay, another way in which you can get data to train your model is from the customer, right? So whether you're a B2C company or a B2B company, usually in the terms there is going to be something in there about data rights, right? And so you're going to want to be thinking about, okay, well, what rights do I have to my customer's data, right? In a lot of cases, the data is scraped, right? So I think I mentioned earlier, the fact that Google is being sued, and so they're being sued in a class action specifically for scraping publicly available data and using that to train their models. And yeah, so I guess I've got a couple examples here. Sarah Silverman and other authors suing OpenAI. I just mentioned Google. The record labels just last week sued Anthropic, right, for using the copyrighted music song lyrics in order to train Anthropic's model, Claude. Okay, so in thinking about how you go about building your models and commercializing to the market, there's going to be a few things that you want to think about. And we've got 5 minutes, so we're going to run through this pretty quick, okay? So number one, we already talked about obtaining clear rights to training data, right? And so for customer data, where you're dealing with an enterprise customer, that can be tricky, because they are reading sometimes your terms, and they're going to want to narrowly tailor the rights that they're granting you to their data to just the specific use cases that they're okay with, right? Clarifying IP ownership of output, right? Because again, that's a customer concern, and they want to know that anything that comes out of their use of the generative AI product that they own. Consider indemnification against output infringing, right? So you all have probably seen in the news, right? Google just announced last week that they're going to provide indemnification for if their output from their AI products infringes some third-party IP, right? And coincidentally or not, right? That kind of came on the heels of Microsoft doing the same thing, right? For Copilot. Consider, how you position confidentiality and data security protections, and how the risk allocation, mechanics in your terms or your agreements operate. require customers to agree to AI-specific terms that include, disclaimers like, acknowledging limitations on the use of AI and kind of usage guidelines, right? Similar to what OpenAI does. And as it relates to bias or other regulatory matters, consider engaging a third party to perform bias audits, right? So if for example, like you were providing an employment generative AI product, you would definitely, this would be required under the current regulations to have an audit performed. So an example of, kind of an implementation of these things in the real world, OpenAI basically says here, for API content, you're opted by default. For non-API content, you're opted in by default, right? Here, you can see a couple of examples of, provisions that you'll often see in enterprise customer agreements, where, the top example is really kind of a more narrowly tailored example where it basically says, hey, you, the customer, acknowledge that, machine learning is a fundamental component, right? You and all our customers benefit from that. And so you grant us the right to use customer data in order to train our algorithms for those purposes, okay? IP ownership, the top example is, OpenAI's terms where they, say, subject to your compliance, we assign to you all right, title, and interest to the output, right? The second example here is a little bit more narrow, right? It basically says, as between you and us, as permitted by applicable law, you own all input and output, right? But as it relates to the output, only to the extent we obtain any copyrights in that output, right? So it's a bit more narrow and focused in terms of assigning ownership of the IP. Finally, indemnification, right? We've got, kind of Copilot's copyright commitment on top, Google's commitment, Adobe Firefly, Shutterstock. Those are two other Gen AI companies that are offering indemnification. The one thing, though, to kind of be cognizant of is that with Copilot, they limit their indemnification only if you use certain filters, right? And so it's possible that they get comfortable because if you're a Copilot user, you agree to Copilot's business terms, and as part of Copilot's business terms, you agree that they can use your content to improve their products, right? So they may have a position basically where, their use of a Copilot user's code for training actually is not an infringement, right? Google is not in the same boat because, like I mentioned, they're basically scraping for their training data. Firefly and Shutterstock also are using content that their users have, right? So they, to some degree, already have the license rights to use that data for training, which makes providing indemnification a lot easier. All right, well, I appreciate it, everyone, and thank you. Have a great rest of your conference.